Hello, I am Syeda Mehar Ejaz, a final year law student at Faculty of Law, Jamia Millia Islamia. Today, I'll be discussing the viability of non-compete clause. Firstly, let's look into the meaning and legal position of the non-compete clause. The era of globalization exhibits numerous challenges to corporate bodies, namely protection of trade secrets, sensitive processes, etc. The concerns regarding the safeguard of confidential information becomes crucial. The challenges and the need to safeguard the confidentiality of information eventuated in common acceptance of the non-compete clause. A non-compete clause or agreement is a contract wherein an employee promises not to enter into competition of any kind with an employer after the employment period is over. They prohibit the employee from revealing proprietary information or confidential information to any other parties during or after the employment. This can also apply to agreements between business transactions or between independent parties. In India, non-compete clauses are governed by Section 27 of the Indian Contract Act 1872, wherein every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is to that extent void. By using the term void ab initio, Section 27 has kept such non-compete agreements and clauses non-enforceable. Now, let's discuss the benefit of the clause. It would be pertinent to look at the benefits of non-compete clauses. Usually, the employers get into non-compete agreements with employees to make sure employees do not enter into the same business and compete with them. For example, if A is an employer who makes B sign a non-compete agreement for not entering into the same business for 1 year in the same state after leaving A's company, then B cannot start the same business with his relatives, friends, and competitors for 1 year. Employees can also benefit from a non-compete agreement when in return for their signature they ask for something of value. Usually, employees ask for appraisal in return that includes promotion or increment in the perks. Now, there are many important rulings of the court. The courts in India have laid down precedents to shed some light on the legality of such clauses. In Niranjan Shankar Golikari versus the Century Spinning and Manufacturing Company Limited, the Supreme Court, while dealing with the issue that whether a contract binding the employee in a contract to not to be employed somewhere else is void under Section 27 of the Indian Contract Act 1987, gave a liberal interpretation to Section 27 of the Contract Act and further clarified that not all non-compete clauses effective after the termination of the employment agreement are prima facie prohibited. Also, in the case of Percep D. Mark Private Limited versus Zahir Khan and another, the aggrieved respondent had agreed to a right of first refusal in favor of the appellant, which extended beyond the term of the agreement. The Supreme Court observed such a contract to be void and stated that under Section 27 of the Indian Contract Act, any restrictive covenant which extend beyond the term of the contract is void and unenforceable. In Wipro Limited versus Beckham Coulter International SA, the Delhi High Court laid down 4 basic commandments for restrictive covenants which were based on the judgments of High Court and the Supreme Court. These commandments stated that, firstly, restrictive covenants, unless unconscionable or one-sided, would not be regarded as being in restraint of trade, business, or profession while in sustenance of a contract. Secondly, a post-termination restrictive covenant that bars the employees to work in the same field would be void. Thirdly, courts should take a stricter view in the employee-employer contracts. And lastly, the question of reasonableness and whether the restraint is partial or complete is not required to be considered at all whenever an issue arises as to whether a particular term of contract is or is not in restraint of trade, business, or profession. Therefore, it is clear that any covenant in restraint of trade is that it is prima facie void and may be enforced only if it can be justified as reasonable in circumstances, by reference both to the public interest and the interest of the parties. However, whether dealing with a non-compete clause, there are no defined rules or fixed parameters to decide is the extent of acceptance of such clauses, and therefore each case turns on its own facts. Thank you.